All right, so today we are going to look at the best approach to answer law questions using the AIRAC. Using the AIRAC. The AIRAC. AIRAC is a well-known, or let me say, is internationally accepted as an approach to answer law problem-based question. Problem-based question. In fact, law questions could be in two ways. It could be problem-based question or essay-based question. You see that criminal law is not a law until the society makes it so. Discuss. That one is essay-based. Essay-based. But sometimes what makes students get to know that this one is essay-based and this one is not essay-based, they normally use the advise the parties. So when you see advise the parties, then it should trigger your mind that you have been asked to answer the question within the context of problem-based to advise the parties. So you are acting as a lawyer and then you are advising the party. And then what you are trying to say is that AIRAC is an abbreviation of which A stands for area of law, I stand for issues, R stands for rules or applicable principles, A stands for analysis, and then C stands for conclusion. And then myself, I make sure to add one to it, which is advice. So AIRAC is what is on the board. And then I just did the extension, I did it myself. Area of law, issues. What does the issue mean? Issue means identify the legal issues. What are the legal issues in the question? R is the rule or applicable principles. What are the rules that I have to use to back the case? You're going to analyze them one after the other. The analysis from the extension, I said that apply the rule or principles to the facts in question. The facts in question. In fact, facts plus rules or fact plus law is what gives us ratio decidendi or decidendi or a decision. Fact. Judges listen to the fact of the case, then they apply rule or the law to the case, and that one will help them to arrive at their decision, conclusion. So conclusion, which sums up the advice to the party. Conclusion sums up the advice to the party or the parties. Let us set the ball rolling by starting with the first one. A, AIRAC. A, area of law. If we talk about area of law, we are talking about the specific area the problem is based. The specific area the problem is based. Please don't say criminal law. Area of law, then you say criminal law. Area of law, then you say constitution. Area of law is a contract. Area of law is a law of tort. No. Under law of torts, which one is that? Someone punched someone's face. So it is battery. Under law of tort, the person didn't punch the other party's face, but the person apprehended the other party, which reasonably, which made the person had a reasonable fear or reasonable apprehension of an imminent battery. Then it is an assault. It is an assault. So the area of law is the assault. The area of law is battery. The area of law is offer. The area of law is invitation to treat. The area of law also could be more than one. It could be offer, invitation to treat, and acceptance. It could be battery, assault, and malicious prosecution. It could be battery, assault, and false imprisonment. It will be battery, assault, malicious prosecution, false imprisonment, and unlawful arrest. It could be more than two areas. It could be one, it could be more than one. So when we talk about an area of law, we are talking about the specific area the problem is based. It is not the subject or the cause itself. say criminal law or contract. It is about a specific topic or subtopic which contains legalities or principles. So for the purpose of our discussion, I'm going to use crime immorality because you have done it a long time. So I am hoping that by now you have been able to go over and over and over. So I decided not to use offer because that is what I'm teaching now. I decided not to use battery and assault because I just finished teaching it. So probably you might have not been able to go over. So I'm using crime immorality, of which if now you have not revised on it, it is your own problem because you have decided not to do it. So respectfully, permit me to use crime immorality. So for instance, here, my area of law is crime and morality. Probably someone came to me and the person was complaining why the law in Ghana is not making fornication a crime because the person traveled outside to a country like an Arabian nation. And then fornication was an offense there. Now he has come to Ghana. Fornication is not an offense in Ghana. And then the person is raising a whole lot of argument. Whilst you are listening to the person as a lawyer, you should be able to get to know that the person is talking within the context of crime, immorality. All the topics we are doing, all of them has its own case. They have their own case in the system. So what you are learning, it has its case in reality. So when you are seeing it, when you are listening to the person, you should get to know that the person is talking from the angle and then within a context of crime and morality. Coming appropriately, again, coming appropriately, again, coming back appropriately. Assuming a woman has come to you that my daughter went out since morning, she has not returned. Since morning, my daughter has not returned. Oh, and then I went to his friend's house and she was not there. From there, I went to where she normally plays. She was not there. I went to farm to see whether she has gone there. She was not there. I went to her school to, you see, if you're a lawyer, people will tell you tons of stories, tons of stories. So it is up to you as a legal practitioner to listen to all these elaborations. In all, what is the woman heading towards? So the woman has come to police station and is making report. So and then the police will say, woman, make their story short. You say, okay, if I'm making it short, eh, eh. And then along the line, I went to where she normally plays. She was not there. I went to her friend's house. She was not there. She came to the house very late, somewhere 11 p.m. When she came, I asked her where she went. She never minded me. She never minded me. And then after 4 days, she can't walk properly. She can't walk properly. I sat her down, asked her, Ekuya, what has happened to you? Ekuya was not willing to tell me. I beg her and beg her and beg her. She was not willing to tell me. I went to talk to her pastor, for the pastor also to come and talk to her. She was not willing to mind me. I went to talk to her teacher. She was not willing to mind me. And then until I told her that if she's able to tell me, I will let her travel from this town and go to Upper East region where her father is, so that she could stay with her father. And then she opened up and told me that, Mama, last 4 days afternoon, I was going to fetch water, and then there was just gentlemen. There was just gentlemen. There were 3 in number, and then they pounded on me, and then the 2 of them held me for the one to rape me. So, as a legal practitioner, listening to the entire agony and then description from the woman, she has said a lot. She went to farm, she went to school, she went to her friend's house, and then the lady was going to fetch water, a whole lot. But as a legal practitioner, what is your area of law? What is the case? Area of law is the case you're going to do your research on and come and stand in for the person. Your area of law is rape. Your area of law is rape. After all, the thing is about rape. Whether the mother went to the farm 20 times or 80 times, that doesn't concern you as a lawyer. What concerns you is that there is a rape. So at the end of the day, those of you who normally like giving long testimonies at church, please be careful. Make sure to bring the case, the area of the case. The area of the case is that you were sick, and at the end of the day, God has healed you. Area of the case. So the area of the case is that there is rape. And as a lawyer, once you are listening, then you get to know, Mama, so do you mean they were three? Then Mama says, yes, that is what she told me. She said that they were three. Two held her for the one to do the raping. Then the lawyer will be nodding her head and make sure to jot down something. Say, so the two, okay, one rape. So the person who raped is the one who committed the rape. Okay. The two, Mama. So the lawyer will be, you see the pen that you can press the top. Keka, ka, and will be nodding his head. Will be stamping his feet. Pa, keka, pa, keka, pa, keka. Will be listening to the case and then will be jotting down something. Mama, did you ask her whether the remaining two also rape her or not? Then the mama will say, that one, she said they didn't do it. It was only one who did it. Then the lawyer will say, I see. Okay. Okay. Then the lawyer says, okay, fine. The person who raped has committed rape as a substantive offense. Number two, those who helped the rapist for him to rape the lady, they have committed abetment of rape. Abetment of rape. Abetment. Forget about the abetment. Abetment means you have helped. You have helped the person to do for the person to do it. So abetment of rape. Okay, Mama, could it be possibly that once they are three, it means that they sat down and planned that this particular lady will come this way, so I will rape this lady and then you help me. Then say yes. As a lawyer, I say yes, that could be possible that they plan it. It can't be random. It can't be random that they just stood up and then they came to do the raping. They will have to sit down, plan where they will hide, how they will do it so that no one will see them. They will say, as a lawyer, then you'll be pressing your pen, the pen top, keka. And you'll be stamping on your feet, keka, pa, keka, pa, keka, pa. You'll be nodding your head, keka, pa. Then you say that, okay. Then if they sat down to plan about it, I could slap them with conspiracy to commit rape or conspiracy to rape. So one case of rape has brought rape, but the rape will go to the person who did it. Those who helped, abetment to rape. Before they came there to hold the lady to help for the actual rape to take place, they sat down and plotted. That plot is called conspiracy to rape. Conspiracy to rape. Conspiracy to rape. So one rape has brought 3 cases. So the person who raped is rape. The person who raped is not part of the abetment because he did the rape. So rape. Those who abetted, they didn't rape, so they are not part of the rape, but they are part of the abetment because they helped. But for conspiracy, all the 3 sat down and they planned. So each one of them will be liable for 2 counts, because the person who raped did not commit abetment, but also commit conspiracy. So rape and conspiracy. Those who abetted never raped, but they conspired. So or each one of them will be liable on two cases. So that is how it is. So for the purpose of our discussion, we are going to look at crime and morality. So we are using crime and morality as our area of law. If that be the case, then let us try and see whether we'll be able to analyze the issues, some of the possible issues under the criminal law. And I'll make sure to juxtapose it with law of contracts a little bit so that you get to know, and then law of tort so that you get to know how it is moving for you to appreciate it. Please, because we are doing different courses. So whatsoever we are doing here is applicable. Please remember, this is method one. Method one. You can go by this approach. This is method one. Method one. Others like this. Others also like other way around. However, each one of them that you use, no one can mark you wrong. So this is method one. To me, this is the most preferred one that I want to me. But I don't know the others, what they wish for. So issues, we mostly use whether or not. The reason being that you are not grown enough to let it be straight, because now you are a learning colleague. Even lawyers cannot say that, cannot go straight. It is the judges that can go straight because they are the one who would make the decision. So lawyers, you approach the issue with some kind of doubt that whether or not, it means that whether or not it shall be determined by the court, by the judges, the judges of the competent court. So issues, example, whether or not the act of appear constitute a crime within the context of Act 29. Very brief. Whether or not the act of appear constitute a crime within the context of Act 29. Someone has committed fornication, and someone they have caught the person, they have sent the person to police station, and then the issue has been processed to court. The issue is whether or not the act of the person constitute a crime within the context of Act 29, fornication. Deborah versus the Republic, where Deborah was found for disrespecting the chief. The issue, whether or not the act of Deborah constitutes an offense within the context of Act 29. The next one, whether or not there is a contract between Possible and CAF University, or whether or not there's a contract between Possible and University of Ghana, Legon. Whether or not there is a contract between Possible and the mentees group. Whether or not Esther could be held vicariously for the act of Mr. Eben. So please look at the constructions. Whether or not Esther could be held vicariously. And I've taught you vicarious liability, holding someone responsible for the act committed by the other. So that is how it is. So issues, you have to make sure to identify the issues, identify the legal issue or problem that needs to be addressed. Make sure to identify the legal issues or problem that needs to be addressed. Identify clearly the factual issues on which advice is sought. The factual issues on which advice is sought. Identify clearly the the fact of the case. Using the mother who narrated lengthy story. The fact of the case is there is rape. That's the fact of the case. Is rape. And then there's conspiracy. There's abetment. That's the fact of the case. Going to the friend's house, going to park to go and check, going to sleep, you couldn't sleep, they are useless. So you, as a lawyer, you give a listening ear. You listen to them and you pick the facts of the case. So the important stage in your answer involves identifying what the question is about from a legal point of view. If you have not been able to get to know from a legal point of view, then you are doomed. You should be able to get to know the issues, and then you react towards them appropriately. So those are the issues. Identify the legal issues or problem that needs to be addressed or identified clearly. Or yes, so address them, and then identify clearly the factual issues on which the advice is sought. So that is how it is. So here we look at what the important stage in your answer involves identifying what the question is about. What is the question about? What is the question about? What is the question about? Then you raise issues in it. You raise issues. Whether or not the act of Deputy Opoku Agyemang constitute an offer or invitation to treat. I hope you are getting it. Whether or not, please, you don't have a problem for that. Like someone also could say that whether or not the act of Deputy Opoku Agyemang constitute invitation to treat. Someone could also say that whether or not the act of Opoku Agyemang constitute an offer. Someone also could combine the two, whether or not the act of Deputy Opoku Agyemang constitute invitation to treat or an offer. And then you come and then analyze them. Before your analysis is when we are going to get to know whether it is an invitation to treat, offer, or it is both. Let us look at the third components of the AIRAC, AI, area of law, I, issues. R is rules or applicable principles. Applicable principles. From you going, Tiwa, you'll be helping me, please. Tiwa, you'll be helping me, please. I think I mentioned Tiwa's name. Tiwa, please, if you're around, help me. Okay. I think she's not around. So we will let Madam, I don't know the rest, whether you are available, Madam Francisca, to help us. Madam Francisca, if you are available, help us with the reading.
Okay, sir, possible. Please, can I start?
Yes, please.
Rules or applicable principles. Identify the principles of law which are relevant to the issues and explain the legal principles given authority, into brackets, case law or statute, or as appropriate. Identifying the relevant law is a filtering process, and this process should include discussion of any areas where the state of the law is in doubt. On the basis of this process, any irrelevant law should be filtered out at this stage, and only the law which is pertinent to your answer should be retained.
That is very good. So when you're talking about the applicable, the rules, here you approach with number one, case law, whereby it is a case course, case law-based course. You approach with a statute, whereby it is a statute based, or it could be the two, case law, statute, like criminal law. You quote your statute, you quote your cases, you also quote your constitution. So this portion is the portion that you let us get to know the cases, the authorities you are coming to use. It is called applicable principles. The principles, Spencer versus Hardings, Harrison versus Nickerson, or Harris versus Nickerson, Hassan versus the state, Chachuchi Carter versus the state, Parker versus Brown, Article 19, Clause 5, Article 19, Clause 11, juxtaposing it with Article 19, Clause 12, Article 19, Clause 21, Criminal Offences Act, Section 10, Criminal Offences Act, Section 1, interpretation. What a crime means, what an offense means. You are bringing out the authorities you're going to use. Deborah versus the state or the republic. You are bringing out all the authorities that you're going to use. You bring all of them down. You list all of them down. This is called applicable principles. Applicable principles. Please, it is applicable principles in the sense that don't go and bring principles or constitutions or sessions that are not relevant to what you are discussing. That are not relevant to what you are discussing. Please, if they are not relevant to what you are discussing, don't bring them. Please. So explain the legal principles, giving authority. Very important. It is called filtering process. And this process should include discussion of any areas where the state of the law is in doubt. Fiscal.
Number 2, state the relevant legal rule or principle that applies to the issues and explain them as to why they are relevant to the issues. Into brackets, students sometimes forget. Oh, okay. Hence, the name relevant cases.
Very good. It is very, very important. After stating the relevant legal rules or the principles that apply to the issue, Harris versus Nickerson, within a context of contract. Let me come down to the context of criminal law. Hassan versus the state. Why are you quoting Hassan versus the state? How is it important? It is like a pastor quoting the book of Romans chapter 5 verse 8. Was we were yet sinners, Christ came and died for us. And then the pastor is preaching on, let me say, so you get money. You get money. Was we were yet sinners, Christ came and died for us. You will get money. May you receive money. You see that there's no correlation. There's no correlation. If you're talking about you receive money, you can use the principle of give tithes. The doors of heaven will be open unto you. The Bible says that what you give, the same shall be measured unto you. You see that you are in line with giving quotations. If you're in line with salvation quotation, salvation. If you're in line with prayer quotations. So the cases that you're quoting, what is the rationale behind you quoting the case? So at the moment you quote a case, a judge or an examiner's attention becomes open to know how you are going to link the quote or the authority to what you are writing. So make sure to link it appropriately. State the relevant legal issues or principle that applies to the issue. When you are done, explain them as to why they are relevant to the issues. Explain. Don't just quote them. Explain. So that is how it is. Let us look at the example. Fiscal.
Example 1, Hassan versus the state. 2, Chachuchi Carter versus the Republic. 3, Gla versus the Republic. 4, Article 19, subsection 5. 5, Article 19, subsection 11. And 6, Deborah versus the Republic.
Good. Please, if you look at it carefully, I have started answering the question, crime and morality. So let me pick my issue to be, which one? My issue to be whether or not the act of appear constitute a crime within the context of Act 29. So forget the rest because the rest belongs to other cause. So whether or not the act of appear constitutes a crime within the context of Act 29. So please, you write area of law, you underline area of law, crime and morality, or crime, morality. Whether you say crime and morality or crime to morality is the same thing. Then you are done with area of law. They will mark you. Then you come to issues. You raise your issue. Issues, you underline. Issues, you underline. Whether or not the act of appear constitute a crime within the context of Act 29. It doesn't mean that the issues could is always one. It could be more than one. Then that one too, you put it down. You go to the third component. The third component is the rules. You write on top rules or applicable principles. Then you underline it neatly. You underline it neatly. And then you start with your applicable principles or the rules, which are the cases. Your rules or applicable principles or applicable authorities are the cases, like the ones that are here. So I'm solving morality and crime. So I'm going to use 1, 2, 3, 4, 5, 6 cases to support what I'm coming to discuss. So, Madam Fisker, I said, yes, from here I said, and explain them as to why they are relevant to the issue. Students sometimes forget. So me, I've listed my applicable principles or rules. Applicable principles or rules. How am I going to explain? Don't forget, I said explain. So how am I going to explain them? Fisker.
Okay. Explain the rules and the principles. Explain the rules and the principles with the cases listed. Example. Good. Morality is about a distinction between good and evil, and it is normative in nature, meaning the court becomes reluctant to enforce them. This could be evidenced in the case of Deborah versus the Republic, where Deborah, the appellant, was charged with the offense of disrespecting the chief, was noted to be a law to protect the chief only, and that there is no evidence that the appellant's conduct constitutes an offense per Act 29. Is it possible? Is it possible?
So we should be climaxing. And then like I told you, so you make sure to explain them and let them fix within the context of the case. Let them fit into the case. So you are explaining them. Please, I told you, look here. Hassan versus the state is the first case. However, we started with Deborah versus the Republic. So it doesn't matter. It doesn't matter. Please be careful. It doesn't matter. You can start from anywhere, but make sure that any authority you have used, you make sure to capture it under the principles, the ones you have listed. So basically, this is what I do. I will give you those gymnastics. This is what I do. Under the rules, I will make sure to leave almost 5 or 7 lines under before I come to the explanation. So that in case I'm writing and I remember one case, then I go back and put it there. I go back and add it to the list of cases that I have up there. Again, in law, when you are typing, your cases must be bolded or must be typed in capital letters. They are called authorities. So they must be bolded or must be typed in capital letters. If you are writing in exams, you write the case, you underline. Sometimes because of time factors, students forget. And then some of the lecturers overlook. But the appropriate is you write the case, you underline. When you are solving exams question, because you can't bold it. So you write the case, you underline. So that is how it is. Now, Friska, be fast for us here.
Yes, sir, possible.
Yes, please be fast for us here.
Okay. Explain the rules and the principles. On the other hand, a crime is an act defined in a statute with punitive measures as stated in Article 19, subsection 11, except matters relating to contempt by superior court, as spelled out in Article 19, subsection 12 and section 10. However, an act that took place before the act cannot suffice a charge against a person subject to Article 19, subsection 5. This could also be supported by the case of Hassan versus the state, where the appellant was convicted of possessing an Indian hemp, contrary to Act 64. It was held that the conviction of the appellant must be quashed or reversed, since his act was committed before the act was passed. This seems to affirm that law is not retroactive but progressive, retroactive but not progressive.
I hope you are following the discussion.
Yes, please.
So you get to know how I'm tackling the cases. I'm explaining my principles. I have not come to the question. No, I have not come to the question. But I am explaining my cases, why I have quoted those cases. I'm trying to let the examiner get to know why I have quoted those authorities, the cases, the act, the statute.
Okay.
I'm trying to explain the rules and then the applicable principles. Fiska, let's go.
2. To contrast, this is the case of Chachuchi Kata.
To contrast, this is the case.
Thank you.
Okay, no problem. Let me come in again. Please, I told you that when you are solving law, for you to let them know that you know what you're talking about, sometimes you compare, you contrast, sometimes you critique. Look at this one. You see that Article 19, Clause 11, I contrasted it with Article 19, Clause 12. That yes, criminal laws is everything that constitutes a crime must be written down, but exception is to Clause 19. The exception is Article 19, Clause 12. The case Hassan versus the state, the contrast, to contrast this, is the case of Chachuchi Kata versus the Republic. When you are speaking under debate or an argument, you don't only go for 4. Though you're going for 4, but you raise some contrasting issues in order to counter what you were talking about. Okay, so to contrast, this is the case of Techukata versus. Yes, let's go.
To contrast, this is the case of Chachuchikata versus the Republic, where though the act, when started, there was no statute in force, but when the act was in progress, a statute was passed to criminalize it, and the appellant went ahead blindly to complete the wrong he has started. This obviously was held by the court as an offense of willfully causing financial loss to the state.
So you see, I mentioned the facts of the case. Please listen. Mention the facts of the case and the holding. Fact holding. Most of the students go by the facts. They forget the holding. What was the decision of the court? Don't say that whereby Techukata was being no. When you are done, make sure to give the holding. When you look here, I gave the holding in the case. It was what? It was held. Oh,
yes.
Yes, it was held that. Let's go here. Deborah versus the Republic. It was noted to be a law. I hope you are getting it.
Yes, please.
So when you're quoting a case, you give the facts of the case and the holding of the case. What was the ratio in the case? Fact plus the holding. Please. The next one is the analysis. Analysis, you are coming to analyze the case. You are coming to analyze the case. So you are coming to apply the rules and the principles that you have explained to the fact of the case. So under analysis, upon all the description, upon all the explanation you have done under the applicable rules, you are merging the rules to the case they have given to you or the question, the rare question. So I call here current. What is going on? I call the rules or the applicable rules what you have learned as a lawyer. You have learned in school. So you know the rules. Okay. Then the person is talking to you. So, okay, I will use this. I will use that. Now, I call the analysis as what I am doing now. Now, what I have, I'm doing my work as a lawyer. Doing your work as a lawyer is to be able to apply your rules, the thing you know under the topic, to the issue in your hand. It is left with 3 slides. Then we are gone. With the issues in your hand, applying it to the issues in your hand. So analysis or application, you are analyzing the case. How do we analyze the case? You first quote the issue. Go and quote the issue. Whether or not the act of appear constitutes a criminal offense under Act 29. Do you remember that issue? Pesca, it's you whose microphone is on. Do you remember that issue?
Yes, please.
You raised that issue. Whether or not the act of appear constitutes a crime under the Criminal Offences Act 29. So if you raise 3 issues, you come and write issue number 1. Whether or not the act of appear constitutes a criminal offense. So you write A, whether or not the act of appear constitutes an offense before you analyze. When you finish doing the analysis, you write B, probably whether or not there is a concept of morality. Then you come and write B, you analyze that one. C, so then you analyze based on the number of issues you have raised. So analysis is equal to issues plus applicable principles. Issues plus rules here. Analysis here is equal to the issues you have raised in the question plus the rules, these rules we have explained, these rules. So area of law will give you an issue to raise. Issues will give you the rules you'll be using. Then you come to analysis or application. Application is issues plus issues plus which one? Issues plus your rules. Issues plus your rules, your authorities will help you to analyze the case well. So let's read this portion. Let's go.
Okay. Analysis or application. 1. Apply the rules and the principles to the facts of the case and explain how it supports your argument.
Good.
Example, whether or not the act of appeal constitutes a crime within the context of Act 29.
You see that I have restated my issue.
Yes, please.
Good. Let's go.
From the case, it could be seen that the act of appeal is not defined in...
What did I say? From?
Please come again.
What did I say?
From the case.
From the case. Some would prefer to say from the case at hand. Some will say from the prevailing case.
Okay.
Some will say from my position now. I hope you are getting it.
Yes, please.
Okay, so from the case.
From the case, it could be seen that the act of appeal is not defined in any statute. Again, no punishment could be found in any statute relating to such act of commission or omission. Using the case of Hassan versus the Republic, Article 19, Clause 5, and Article
Using the case of Hassan versus the Republic. Okay, yes, now, good. Move on. Okay. I was rather misled.
Okay. Using the case of Hassan versus the Republic, Article 19, Clause 5, and Article 19, Clause 11, the act of appeal is just an immoral, but does not constitute an offense.
You see the analysis?
Yes, please.
You have analyzed the issue at hand. You have analyzed the issue at hand. So if you are throwing to court the judges, I therefore, my laws, submit to your high table that the act of appeal is just an immoral, but it does not constitute a crime. It does not constitute an offense because they are supposing it to the case of Hassan versus the Republic, Article 19 Clause 5, Article 19 Clause 11, as I have explained earlier. The act of appeal does not constitute an offense. I rest my case, my lord. Then you rest your case. So this portion becomes this portion where I was concluding. The act of appeal is becoming your conclusion. Your conclusion. You are concluding. You are concluding. So this leads us into the conclusion aspect. AIRAC, the last one, is C, conclusion. Every problem question must be concluded. Every problem question must be concluded. Every problem-based question must be concluded. And I said that conclude on whether there should be an action or not, and whether the parties will succeed or not. So, my lord, I thereby bring to your notice that the act of appeal does not constitute an offense, taking into account Hassan versus the Republic, Article 19, Clause 5, Article 19, Clause 11. I thereby conclude on my case that an action against appeal must not and should not succeed. Or sometimes you use passive sentences, not active, because you're talking to authority, higher authority. So I thereby bring it to your table that an action against appeal should not succeed, or appeal is not liable. Appeal is not liable, or appeal is not supposed to be convicted. That is it. And then you rest your case. So that is a conclusion. You have advised the parties. Sometimes if they say advise the parties, if the party is now going, then you tell the party, this one, an action against appeal will not succeed though. So please stop. So you get to know where the one you are advising. Sometimes they say advise the party. Say an action against appeal will not succeed since appears act is just an immoral act, but it is not an offense or a crime. I think I have done justice to whatsoever I'm supposed to teach you. So that is where we will bring our discussion to a closure. Go and look through it. God willing, tomorrow, our next class, when we are starting, I will take comments, questions on this. Take your time, let it reflect in your mind, jot points down, and then God willing, tomorrow in our class, before we start the original class, I will make sure to accept your questions on this. So let it reflect your mind. So without much ado, I, Alexander Osei Kwame Possible, hereby suggest that if there is no objections, suggestions, contributions, we bring the meeting to a closure and postpone it up to God willing tomorrow, 2 a.m. Is there anyone to second?
I second, sir.
Good. So we are closing. All right. Take good care of yourself and make sure to enjoy your day.
You too. And enjoy your day as well. And good luck.
Okay. The same to you. Bye-bye.
Bye.